No, you won't lose your job if you make a claim against your employer. It is quite a daunting idea, making a claim against your employer. You might feel as though you don't want to jeopardise your job or your relationship with your employer. However, you cannot legally be dismissed as a result of making a personal injury claim. A reasonable employer shouldn't dismiss you as a result of making a claim. However, if you feel as though you have been unfairly treated or worst case scenario you are dismissed, you can seek employment law advice in order to obtain your rights in relation to what action you can take against your employer. Employers have employees' liability insurance to cover them in respect of any claims that an employee may make against them if they sustain an injury as a result of an accident at work. First of all, definitely report the accident to your manager or supervisor. The details of the accident should be recorded in an accident report book. Details that go in the accident report book are things such as the date, the time, the location of the accident, if there were any witnesses, what injury you sustained, if you had to seek medical attention. Don't sign the accident report book until you're happy with the contents of the same. You should get the opportunity to review what has been recorded before you approve it. If you have sustained the injury, then you may want to go to the hospital or your GP. I would definitely recommend this, as any details of your injuries will be included in your medical notes and records, which can be referred to later on down the line. In terms of your financial losses, it may be that you have to take some time away from work because you're unable to work due to your injuries. There may be financial losses that you incur, such as medical expenses, treatment costs, travelling, parking expenses, assistance provided by family or friends, anything like that. Keep a list of them and then retain any receipts, and then you can include the same as part of your claim. It would also be ideal if you could make a diary or a log of the progression of your injuries, even photographs of any visible injuries that you may have sustained, as later on down the line you will be required to see a medical expert who will examine you and prepare a medical report detailing what injuries you've suffered from, how long they're likely to last. It would be helpful for the expert to see a history of how your symptoms have progressed, and also photographs of your injuries so they can see what they were like at the outset. I'd recommend that you take multiple photographs of the accident location and perhaps a video just to support what's happened, to show the accident circumstances. Maybe your employer has got CCTV footage of the accident itself. Anything that can support what happened would be very, very helpful to the claim. If there are any witnesses, take their name, ask them if they'd be prepared to give a statement as to what actually happened. They may be feeling a bit daunted about providing a statement if they're a mutual employee, a mutual colleague. However, some employees may be willing to do that for you. It may be that there are colleagues who witnessed the accident who would be willing to provide a witness statement as to the accident circumstances. Any evidence that you can get in support of how the accident happened will come in useful in the event liability is in dispute. If you're injured at work when you're not wearing personal protective equipment, you can still make a claim. It's an employer's duty to provide an employee with personal protective equipment. It's also an employer's duty to show the employee as and when to wear the protective equipment. If the employee chooses not to wear the PPE, then they could be held contributory negligent as a result of any injuries they may sustain as a result of their failure to wear the same. Even though an employer is vicariously liable for the negligence of the employee, if the employee does cause or contribute to their injuries, then they could seek an indemnity for contributory negligence. If an employer has failed to provide PPE to their employee and the employee is injured as a result of there being no PPE in place, then there is likely to be a claim against the employer. If you're injured at work, which results in being unable to return to your previous role, your employer is under a duty to adapt your previous role to enable you to return to work as soon as you can. This may be putting you on lighter duties or giving you an alternative role. Your employer might also offer to fund and arrange some rehabilitation which will assist with your recovery and get you back on your feet and get you back into your role as soon as you can. If you find that you can't return to work as a result of being injured, you might claim statutory sick pay, or failing which you can make a claim for loss of earnings, future loss of earnings. There's also the option to make a claim for disadvantage in the open labour market if a medical expert decides that because of your injuries you're unable to return to that particular role. Awards for disadvantage on the open labour market can be quite big, however it all depends on the level of handicap which will be decided by the medical expert when you see them at an assessment.